Talk shoes. Recorded live.
Hello, ladies and gentlemen. This is Rod. Got some new information. Got my hands on some books. I want to repeat them slowly so you can have the chance to write them down. And it is something that you may want to get your hands on because it explores more of the issues of what we're dealing with these courts. So many of these people are right about the court under the law and equity. What I have been teaching you was the law side of this thing. The constitutional side, the congressional record side, the statutes at large, the codes of federal regulations, USC codes, administrative codes, and their rules and regulations. As we have discovered in DC, they have suppressed all this. But these courts are running under three issues that we were not aware of. And I'm going to give you notification of what is I have discovered. Take it for what it's worth, like anything else. We're not twisting your arm, but go back and look at it. Now I'm going to give you the name of the book, so you should have time to have pencil and paper by now. One of them is called Library of American Law. That is Library of American Law and Practice. Excuse me, my voice is getting hoarse. All right, that's Library of American Law and Practice. Equity, Equity Procedures, Trust, with an S, Trustees, and Promulgated Writs. That's one book. I got this off of Amazon for about $33. This book gets into a lot of good information that we have been missing. The other one is a treatise on equity jurisprudence. That's a treatise on equity jurisprudence as administered in the United States of America, as administered in the United States of America, adopted for all the states, adopted for all the states, and to the Union of Legal and Equitable Remedies, and to the Union of Legal and Equitable Remedies under the Reformed Procedure, Volume 1. They have several different volumes out here. They got Volume 1, Volume 2, Volume 3. They are about $35 to $40 a piece on Amazon. Ladies and gentlemen, we have an issue with these courts because according to what I have been reading here under the Library of American Law and Practices of equity, equity procedures, trust, trustees. On page 90, section 119, federal courts, personal jurisdiction. The general rule of personal jurisdiction in the federal court is based on diverse citizenship. Let me read that again. Personal jurisdiction. So when these judges are claiming personal jurisdiction, or we have personal jurisdiction in their court, they're not telling you what that personal jurisdiction is. And we have now discovered what it is. The general rule of personal jurisdiction in the federal court is based upon diverse citizenship. Now think about what I just said, diverse citizenship. Think about it. It requires that the plaintiff and defendant shall be citizens of different states in order to give jurisdiction on personal grounds. If both parties owe allegiance to the same state, the federal court refuses to hear their case, even though they reside in different states. Citizenship, not residency, is the test of the personal jurisdiction of the court. This distinction becomes important in the case of corporations, especially interstate railroad corporations, in as much as a corporation is inputted to have citizenship in the states wherein it obtains a charter. The federal court, on the grounds of diverse citizenship, has jurisdiction over an act between citizens of different states. Although they may reside in the same state, the federal statute requires suit to be brought in the district in which the defendant has residence. But this rule permits suits against a corporation in any district within it exercise its charter, power, and maintains an agency. Ladies and gentlemen, now I'm going to lay something out to you. We're talking diversified citizenship. Through congressional statutes, through the history that we've talked, through the Reconstruction Act of 1867, whenever the federal government came down and took over the southern states at gunpoint and required them to relinquish their state citizenship to take on the federal citizenship, this now becomes a diversified citizen. You may live in the same state, but you get two different citizenship. You got federal citizenship and state citizenship. Now think about what we're going to get into here for a minute. The federal government came into the state, which was the governor's office, the legislation, anybody who took an oath to a public office. The government came in and turned them into a federal citizen under that 14th Amendment, Section 2 and 3. This now comes into diversified citizenship. And when they did the 1868 14th Amendment, and then they turned them into a corporation in 1871, and they put them under international law in 1945, that puts this whole system in diversified against you and I. This is one of the ways that they're dragging us in. They're dragging us into these courts, not only on the federal level, but on the state level, because we are diversified. We are state citizens, they're federal. This is a very significant issue here, because every time we've tried to sue these suckers, our cases got thrown out. I have worked with a couple of people, and we have now went into a diversified citizenship under that alien tort claim, Title 28, 1350, and under diversified citizenship of Title 28, 1332 into a federal court, and it stuck. A case got reopened based on this, where we are going back in and naming these people as 14th Amendment citizen under alien tort claim, under diversified citizenship. This is one of the doors that we're dealing with. This is something that in this book gets in. This is how they're dragging us into the county courts, city courts, federal courts. Not because we have residency in the same state or residency in another state, they're bringing us in under diversified of citizenship. National citizenship, private citizenship, whatever you want to call it, compared to that of federal citizenship or foreign citizenship. Because under the International Organization Immunities Act, they now become foreign. This now means they have to follow the foreign sovereign immunity side of this thing. They have to sit down and notify the proper parties, and they're not doing it. Under foreign sovereign immunity, they have to run us through the Department of State, and they have to get our permission. This is why that Cor Nobis paperwork that I did back in 2008 was an issue. What that college professor said here said that this would overturn every single court case and that 99% of the prisoners would have to be let loose. The people understood this. Right here, ladies and gentlemen, what we're getting into. And I'm going to read you the title of the book again. So for those of you who have come in the middle of this, I'm going to read this book to you again. Get a pencil and paper. It says, Library of American Law and Practice, Equity, Equity Procedures, Trust, Trustees, Promulgated Writs. I got this on Amazon. Ladies and gentlemen, this is very significant for us to sit down and understand what they're doing and how they're doing it to us. They are also bringing this in, and this court has two doors. It has a lawful door, which is talking about the statutes, the codes, the rules, and regulations, and it has an equity door. It is the problem that we're dealing with is that these courts are operating under both law and equity at the same time. And they cannot operate under law and equity. All right. Here is the question in these states is the right of relief, conceding that the plaintiff is in the right court. For since there is but one court for both law and equity, of course he cannot go to no other, nor in the full codes of the state can he alter his form of action or change sides in the court. If he seeks what would be equitable relief under the old practice, the question he must meet, but if he seeks what would be equitable relief under the old practice, the question he must meet belonging not to equity jurisdiction, but to equity jurisprudence. Does equity provide relief for such a case? Our subject then is to receive treatment for those states having separated equity courts or separated equity dockets in the practice of law courts. And first of these states have separated chancery courts. Ladies and gentlemen, this is how we're getting hammered in these courts. The issue that we need to start challenging the jurisdiction of these courts comes back in the fact that we need to challenge them right off the bat, but they're not allowing us at these arraignments. That's what it says here under Chapter 10, Section 122, objection to jurisdiction. When to be made. It's under Section 122, when to be made. It is the general rule that a defendant wishing to challenge the jurisdiction of the court must make his objection before he answers to the merit of the case. The reason for this rule is that the court may not waste its time in considering manners in which it may have power to pronounce a decree. Hence, a party objecting to the court's action upon the case must present the same in limine at the offset. If he withholds such objections and passes on to the later state, in the order of making a defense, files an answer denying plaintiff's allegation and his right to relief in the permission, he is held to have already waived his right to challenge the jurisdiction and consented that the trial should pass upon the merit of the conveyance. Ladies and gentlemen, this is where we're getting hammered at. They're not allowing us in the very beginning, right at your arraignment, before you plead, we're supposed to be able to challenge the jurisdiction of that court. And the issue of that challenge would be, are you bringing this in under diversified citizenship? Are you acknowledging that our citizenship is different than yours? That's one. The other issue is this a court of law, or are you operating under equity jurisprudence? These are the three things, the three doors, ladies and gentlemen. These are the three doors. Whether you're bringing this in under diversified, under foreign state, which means you have to go through the Department of State, and you have to have my permission, or are you just a court of law, or is this a court of equity jurisprudence? These issues is what has been concealed from us. These issues is what has been denied from us. The information that we're pulling out of these books, ladies and gentlemen, it is absolutely amazing, because you have what is called constructive fraud classification. Lord Hardwick classification of fraud in Chesterfield versus Jason quote in a previous section, and generally adopted by the writer on equity, named three classes which belong to the dominion of constructive fraud. One, that appearance from the intrinsic nature and subject of the bargain itself. Two, that presumes from the circumstances and condition of the intimate parties to the transaction. Three, that which is imposed on third person, not parties to the transaction. Ladies and gentlemen, this book has a lot of information that we need to start understanding of how these courts are dragging us in. Are they dragging us in under diversified citizenship that they're not telling us this? Is this going to be a court of law? Or is this a court of equity jurisprudence? These are things that we were missing. I got these books on Amazon. I ordered them. Like I said, about $33 a piece, some of them like 40. But I'm giving you another line of thought of what we're dealing with in these courts. Something that they're not telling us, something that they're not disclosing to us. This is why we're being told by the lawyers, you can't use law in this courtroom. Well, if we can't use law, then you're dragging us in under equity. But you cannot use the statute. You cannot use the statute to drag me into this court and then switch this court over to equity and not tell me. You cannot charge me under a state code, charge me under a federal statute, and then turn around and bring me in under diversified, bring me into the equity side of this thing and deny the law whenever it was the law that brought me in here. Because under law and under equity both, ladies and gentlemen, it requires clean hands. It requires that if we're going to follow the law, it's like I did up there in D.C. when I asked Kessler, where is the corpus delicti? Where is the injured party? And she stated, you broke the law. She now told me this was a court of law. And when I proceeded to explain to her the violations under the law that the prosecutor did, she walked off the court, walked off the bench, and walked out of the courtroom. Brother, she ran. The moment they accepted my birth certificate, just put it under equity. Ladies and gentlemen, something to think about. Something for you to consider. But they are bringing us in under diversified citizenship. So that now means that if we want to sue them, we have to go through the administrative process like we talked before. You have to go to the agency. You have to file a complaint. If they don't answer, or they come back and say you need to sue us under Title 28, under 2401, or Title 28, 26, 74. Let me look that up, make sure that's the right number. C 2674. Liabilities of the United States. That's the tort claim. Okay. So if we go in under Title 28, 2401 or Title 28, 26, 74, these are tort claims. And if we would turn around and take them in under Title 28, 1350, all right, Title 28, 1350, alien action for tort. The district court shall have original jurisdiction for any civil action by an alien for a tort only committed in violation of the laws of the nation or a treaty of the United States. Read that again. Title 28, 1350, alien action in tort. The district court shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the laws of the nation or treaties of the United States. Now, what does that mean? Well, let's get into this for a few minutes. Let's talk about this. These lawyers, public officials, swore an oath to the Constitution in order to obtain their job. They swore that they would uphold the Bill of Rights when they took their job. They acknowledged that they would uphold the laws of the United States when they took their job. Problem is, when they took their job, they've walked out of that constitutional side of this and walked into the corporation side or the foreign national side under the UN, which now makes them an alien to you and I. We are now aliens to them. Under this Title 28, 1350, we now can bring a claim against them, but we have to have notified the proper procedures of walking them up through their agencies under the administrative. Now, let's pull up Title 28, 1332. Title 28, U.S.C. Code 1332, Diversity of Citizenship, Amount and Controversy and Cost. The district court shall have original jurisdiction of all civil actions rather than matters in controversy exceeding the sum of a value of $75,000, excluding of interest and costs, and is between citizens of different states, citizens of a state and citizen or subject of a foreign state, except the district court shall not have original jurisdiction under the subtitle of any action between citizens of a state and a citizen subject to a foreign state who are lawfully admitted for permanent residence in the United States and are domiciled in the same state. Citizens of different states in which the citizens or subject of a foreign state are additional parties, and a foreign state defined under 1603, which is Foreign Sovereign Immunity, Section A of this title, as the plaintiff and citizen of a state of a different state. Let's go down to 1603. Title 28, 1603, definitions, as proposed for this chapter. A foreign state, except as used in 1608. And we know what 1608 is. That's public officials. Of this title include a political subdivision of a foreign state or an agency or instrument of a foreign state as defined in subsection B. This is why we're not suing the agency, ladies and gentlemen. We're not suing the United States because that is a fictitious entity. We are going after those who work for it. We can't sue a piece of paper, but we can sue the person who is holding that piece of paper. Ladies and gentlemen, this is a significant breakthrough for what we are discovering. It is a very significant breakthrough for what we are discovering. Is that we're now beginning again to pierce their armor and find cracks in their armor. For those latecomers coming in, I'm going to read you the titles of these books again. Get a pencil and paper ready. It's called Library of American Law and Practices. Equity Procedures, Trust, Trustees, Promulgated Writs. And the other book is a treatise of equity jurisprudence as administered in the United States of America, adopted for all the states, and to the unions of legal and equitable remedies under the Reform Procedure, Volume 1. There's several different volumes to this book. I read these things at the beginning of the show. But ladies and gentlemen, it is important that we now start to understand the legal side of this, and we start to understand the equitable side of this, and we start understanding the dragging us in on a diversified citizenship. That right there, ladies and gentlemen, is the key factor. Diversified citizenship. That diversity puts us under foreign sovereign immunity. Because as I read to you under that Title 28-1332, it dropped you into 1603, which is foreign sovereign immunity. These were pieces that we have been missing. We need to know what I have been teaching from the congressional records, the statutes at large, the codes of federal regulations, United States Code. All this stuff applies to them on how they are to operate and how they are to deal with us. I'm giving you some food for thought. I'm giving you some books to get off of Amazon, to start reading, start understanding of what their procedures and practices are. Again, we sit here and talk, we need their manuals. We need to get a hold of their manuals. Ladies and gentlemen, we got a hold of some more of their manuals. We need to understand. We need to challenge the jurisdiction right off the bat. Are you bringing me in under diversified citizenship? Is this a court of law or a court of equity jurisprudence? And I realize they don't allow us because I myself have been in these courts. So this isn't somebody who's given advice who's never been inside of a courthouse. I've been there. I know how the arraignment runs, and they do everything they can to keep us from bringing anything up. Because it goes into, if we don't bring it up at the beginning, then we agree to it. And we are being forced to agree to a plea when we should be able to challenge it under equitable, law, or diversified. Under them three things, we should be able to challenge this right off the bat. And this is why the moment you get stopped, the moment they knock on your door, that's when I sit down and I've told you people, when they stop me, I have paperwork the next day sitting in the court. This new paperwork needs to start being challenging diversity, law, or equity jurisprudence of how this court is running. And until this is disclosed, the court can't move any further. And I realize we've been there and we've got our butts hammered on this. And we're not in here to discuss that. You're here to make a plea. But we need to at least put it in writing in the court before we have an arraignment. It's a real simple document. All you have to do is now come so-and-so. I now challenge the court under its jurisdiction. Are you bringing me in under diversified citizenship? Are you going to operate under a court of law or you operate under court of equity jurisprudence. Sign your name, do a certificate of service, file it into the court. These are the three things we need to start asking. And we need to start pushing and objecting in these courts. I object until I get my answer of the jurisdiction of this court. The judge says, I got you in personal jurisdiction. Then fine, then you're telling me you brought me in under diversified. You brought me in under foreign state. Because under diversity falls under foreign sovereign immunity. You failed to notify the proper people. You failed to go through the Department of State to get permission to drag me into this court. Therefore, this court has no subject matter under diversity. Because I do not give consent. If this is a court of law, then let's talk about the law that's being violated. Well, you can't bring a law up in this court. Then you brought me in under equity. Then you can't use the statutes under equity to bring me in here. Because under equity jurisprudence, you can't use the law. Are you planning on obtaining some type of dollar amount off me, which is equity? And equity, under the legal definition, is fairness. Ladies and gentlemen, give some thought of what we're sitting here saying on this show. Give it some thought. Those of you that have filed third-party interveners into my case, now we know how to bring them in under diversified citizenship. We notify the agencies, and then we bring them in and sue them under diversified and under alien tort claim, under Title 28, 1350, and under Title 28, 1332. And that tort claim is under Title 28, 2401, and it starts on 2674. All this is under Title 28. Ladies and gentlemen, we got new avenues, we got new doors, and I'm not done fighting yet. All they did was make me do some more research. These people have not learned. The more you screw with me, the deeper I dig. And now we're digging into the equity side of this thing. I give you some books to get a hold of. Go back and start reading. Thank you. And any and all donations, I'm sitting here telling you again, any and all donations is welcome. Because of the research, the price of the books. The address here is P.O. Box 435, High, H-I-G-H, Shoals, S-H-O-A-L-S, High Shoals, North Carolina, 28077. Ladies and gentlemen, I may be relaxing on some of this stuff, but I am researching new books. What we did on the law side is not wrong, because according to the books, according to the jurisdiction of the court, it has 3 jurisdictions. One in law, one in equity, and one in diversity. This is something we didn't understand. And the more we're getting into it, the more we're understanding. Thank you. You all have a good day.